Welcome to the show, How to Probate an Estate. Virginia probate is a process to settle the financial affairs of a deceased person and then transfer the remaining probate assets to the beneficiaries. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets are delivered to the decedent's loved ones. Some probate train rides are short, while others' probates seem to never end. In our show today, we are going to focus your attention on the assets that are owned by the decedent. You will be looking for certain information about those assets that may prove helpful in shortening or eliminating the probate journey in order to settle the estate of your loved one. With us today are two prominent Northern Virginia attorneys to share their insights on these topics. Southey Walton has been practicing law in Northern Virginia since 1993 and co-founded the law firm of Ferguson, Walton, and Shansab PLLC in 2010. She concentrates her practice in the fields of estate planning, estate administration, and trust administration. Southey previously served on the Board of Governors of and as the chair of the Virginia State Bar Trust and Estate Section, and she is currently a member of the Northern Virginia Estate Planning Council. Jonathan Bromley is also joining us. He is the founder and the owner of Bromley Law in Fairfax City. Jonathan's practice focuses on trust and estates administration and litigation. Jonathan previously served as co-chair of the Fairfax Wills and Trust section of the Fairfax Bar, and he clerked for Fairfax Commissioner of Accounts Jack Rust. Please join me in welcoming Southey Walton and Jonathan Bromley. Thank you both for coming to visit with us today. You know, we hear so often about clients, they call us up and they have had someone pass away and they've rushed up to the probate office to get qualified. And yet, often that is not the best course of action. So they tell us some of the reasons why someone might want to think carefully before they get qualified.
Sure. By qualifying as a personal representative of an estate, a person takes on all of the responsibilities of making sure that it's done correctly. A few of the things that need to be done are collecting assets, paying debts, making sure that everything's distributed properly, filing tax returns for the decedent, and also making all the probate filings that are required. If an estate might have more debts than it has assets, that's an even trickier situation because the creditors have to be paid in a certain order. Mm-hmm. And those are situations in which you have to think hard before you go and qualify as a personal representative.
Sure. So some of the information that people need to gather then would be they have to identify the assets and the debts and things like that. What would they be looking to do?
The value of the assets and how they're titled, whether they name beneficiaries or whether they're owned jointly with the right of survivorship. And also the debts. You want to make sure that you have an idea of what the debts are and whether there might be anything potential lurking out there, like a lawsuit if someone died in a car accident, or those are things that you should be aware of before you make that decision to qualify.
Sure. Well, Jonathan, it sounds like there's a lot of work to be done, but boy, you need a lot of information. How does someone actually gather that information so they can become informed about the assets and the debts?
That's a good question, and the fact is, people are unique. So are their affairs usually when people try to figure it out after they pass. And so there's really no rule of thumb of how you go about this. You usually just have to roll up your sleeves and dive right into their papers, into their affairs. I find that a good place to look first is to check this person's mail. If you can have it forwarded to you as the person in charge, that's extremely helpful. It's also a good idea if you can get onto their computer, check their accounts online, check their emails. You know, just good places to look to try to start gathering the account information, their assets, and get an idea of who they might owe money or what creditors might be out there. It's also usually a good idea to talk to family and friends and the people that knew these people well to get a good sense for, again, what they own and who they might owe.
Okay, well that sounds like a lot of work. Now when you do that, some of the things you begin to identify are this thing that we hear all the time called non-probate assets. Why don't you tell us a little bit about, just what is a non-probate asset, just generically, what is that supposed to mean?
Sure, and I mean, when you're looking at the person's assets, you're also, as you mentioned, finding assets that don't necessarily need to go through probate. So the term itself kind of helps us understand it a little bit, But the fact is, these are assets that were designed to go directly to beneficiaries or go directly to other individuals and entities. And therefore, what we don't need is we don't need an executor or an administrator to come in and to qualify in order to transfer those to the individuals they have been designated for.
Give me some examples of non-probate assets that people would recognize if they were watching this program today.
Sure. Well, I think there's three main categories that people are going to run into. First, you're going to find joint accounts. And typically, we refer to these usually as survivorship accounts as well. So there'll be a joint tenancy with the right of survivorship. And you might see this with bank statements, with bank accounts and other financial accounts. And what that says is that all the people on the account are actually the owners. And that when one of those pass, the other people on the account become the owners at that point. And these things, again, because they already have multiple owners, people with check writing authority, it doesn't have to pass through probate. It just becomes the survivor's property.
Okay.
You also might see tenants by the entirety out there, which is the same thing as a joint account with survivorship, designated for husband and wife property. And the reason why it has its own name is there's extra protections there available against creditors. You'll also see POD accounts, which we technically called payment on death accounts. And those are your standard beneficiary designations on different bank accounts, stocks, and the like, that basically direct the institution, when I die, pay this asset over to these people, liquidate it, and pay the proceeds to these individuals. The third account people are likely to run into are called transfer and death accounts, or TOD accounts, which are very similar to POD, but instead of ordering the institution to pay the proceeds to these individuals, they're directing the institution to just merely retitle it into the name of the beneficiaries. And we see that a lot with publicly held stocks and also family corporations and closely held businesses where people have basically said, when I pass away, I want my son to be the owner of this stock.
Okay, well those are good examples. Now, so that there also is, those all sound like really, really good techniques, and so you avoid probate and all of the costs and hazards of probate, but there can be a bunch of pitfalls that can arise from using those techniques. Tell us a little bit about some of the things that you've encountered in your practice.
I think probably the single greatest pitfall with payable on death or other beneficiary designations are where a client decides to name one child, for instance, adult child, as the beneficiary, and then expects that that child is going to divide the account with the other children. I think a lot of people don't realize that beneficiary assets don't pass under the terms of the will. A lot of times people think it's going to be distributed under, as set out in the will, but it's not. It goes directly to the beneficiary, and that person can keep it and doesn't have to split it. And even if they do split it, there can be gift tax issues sometimes, where the person is making a taxable gift by dividing it among the other beneficiaries.
So there are some significant hazards if you don't think through what you do when you actually title that account.
Also, with beneficiary designations, a lot of times people forget to update them when a beneficiary dies or in the event of divorce. That's often a problem.
And beneficiary designation, you're referring to like a life insurance policy or a retirement account.
Or a TOD or POD beneficiary,
okay, true.
yes.
Sure.
And with joint accounts, there are a few additional potential problems because during your lifetime, if you name a co-owner on an asset, that person is an owner. They can withdraw money from an account. If there's real estate involved, they're going to have to sign off on any sale of the property. This works very well for married couples in a lot of cases, but for a parent and an adult child, it can be sticky. Also, if the co-owner has creditors, they can try to reach that account. So there are a lot of potential problems with joint accounts, especially.
So it really does require some thought in doing that. So this is, but these are tools that we look for as a process of evaluating, say, when someone's passed away. Now, we also have these various assets that are not necessarily non-probate assets, but they pass outside of probate. So, Jonathan, tell us a little bit about how, for instance, life insurance passes outside of probate.
Well, life insurance is interesting because the decedent, the person that owned the policy, didn't actually own the proceeds that are payable. What they had was essentially a contract with an insurance company or a financial institution to pay certain individuals or to pay an entity, whether it be a trust or a business, upon their death a set sum. So the decedent didn't actually own an asset. It just had a deal essentially with a company to pay other people. And so those assets will directly go to the beneficiaries. And typically a beneficiary would say, well, I believe there's a life insurance policy, I'm a beneficiary to it. And they just need to make contact with the institution to make arrangements for its payment. Very rarely will life insurance proceeds end up with an estate. And typically that only happens when people forget to name beneficiaries to their policies or haven't reviewed it in so long that the beneficiaries are all now deceased. When that happens, it's actually usually bad news, because once the proceeds enter the estate, they're now subject to your creditors. Well, if they just go directly to the beneficiaries, those proceeds aren't subject to your debts because you never owned the asset in the first place.
Very good, very, very good point. Now, so there are also two of the biggest assets, one of the biggest assets that we have in the course of evaluating, probate transfers is the retirement accounts, and related to that would be annuities as well. Tell us a little bit about how those pass outside of probate, or can pass outside of probate.
Retirement accounts and annuities also almost always carry beneficiaries. People name their primary and usually a contingent beneficiary on those accounts. Sometimes people forget to name the contingent beneficiary and they get into trouble. The retirement accounts and annuities, like the life insurance policies, do have some level of protection from creditors if they're paid directly to beneficiaries, but if they're paid into the estate, the creditors do have access to those monies. Retirement accounts in particular, and annuities to a lesser extent, it's very, very critical to keep beneficiaries other than the estate named on those accounts, because individual beneficiaries in certain types of trusts, but not estates, have the option to stretch out distributions from the retirement accounts over the life expectancy of the beneficiary.
Okay.
Which allows them to defer the income taxes.
So it's a big planning opportunity.
Right. With the estate, if it's paid into the estate, it's going to be paid out very quickly, and the income taxes are going to be due all up front.
Ouch. Ouch, that can be painful. Well, those are very interesting, and those are good things to look at as you begin to evaluate the assets that might have to go through probate or not go through probate. But we do eventually end up with typically some collection of a bank account or a brokerage account that is not have a POD or a TOD, there's no joint owner, and just sits there. And we have to probate that. Now, Virginia, like many states, has adopted some small estate procedures to kind of expedite that process. But Sadly, tell us a little bit about those small estate procedures that we have in Virginia. Just overview that quickly.
Just a quick overview. There are a couple of statutes that allow transfer of assets without the full qualification, full probate process, and those allow the qualification process to be avoided. And they also provide some level of protection to the people who are supposed to receive those assets.
So the first one, there's two of those, I understand. So the first one is a little more formal, and generally, this one I think we talked before the program that this is probably a good one where you might want to go to the probate office. You're not necessarily going to start a probate, but they're going to give you some documentation that will allow you to accomplish something. This is Virginia Code 64.2-601, where you get a special kind of affidavit. Tell us a little bit about what are the parameters for that kind of affidavit.
Right, and we call it normally the small estate affidavit. This is available if the total value of the personal estate is $50,000 or less. That doesn't include real estate, but it does include any kind of assets like bank accounts or anything else that's passing through probate.
Okay.
It also requires that you wait at least 60 days after the death of the owner.
Okay.
You do also need to certify that no one has been appointed as personal representative of the estate and there's no pending appointment.
Okay.
And if there's a will, that does need to be taken down to the clerk's office and probated. Now, probate in that case is really just recording the will and proving that it's the actual will. It doesn't require anybody to be appointed as or qualify as personal representative and go through the whole probate process. In the affidavit, you have to state that all of those requirements were met and also identify the person who is making the claim and why they're entitled to make the claim. You have to identify all of the people who are successors to that account. So that could be under a will, or it could be under the intestacy statute if there's no will. And you need to show the names and addresses of those people and the names of the people who are making the claim, and that it also has to state that the claiming successor has a fiduciary duty to promptly to safeguard the asset and promptly deliver it to the successors.
Well, it sounds like there's a lot of things to say, but in short, though, we're basically, you know, if there is a will or if there is an intestacy, we're basically capturing in that document, you know, directing where things should go, consistent with what the will would say anyway, or what the intestate statute would say. And that document, which gets certified by the probate office, is kind of your ticket when you go down the street to Wells Fargo or whatever the bank might be, that they'll then turn that asset over to you.
And the affidavit can either be issued by the probate office, which is often the easiest way to do it, or it can be prepared by an attorney or another person outside of the probate office.
Okay, good. Good. Now, that's a very good tool. Now, Jonathan, there is a second procedure that's available, which is a little less formal, and that's Virginia Code 64.2-602, which again is a small estate affidavit but has different rules. Tell us a little bit about that small estate procedure.
As you mentioned, Richard, it's a little more informal in that it doesn't quite require all the steps that the longer form small estate affidavit would require. You can only use this one when you're dealing with an asset that is worth less than $25,000.
They're working on a single asset generally.
Typically, yes. Okay. Each asset that you use it for has to be worth less than $25,000. But all that you need to certify when you prepare the shorter form affidavit for those smaller amounts is that this person has been deceased for 60 days and that no person has applied or has become personal representative of their estate. Unlike the longer form, it does not require a trip to the courthouse to probate a will, and you do not have to certify the other several items that are required for the larger small estate affidavit assets. Okay. Unfortunately, though, these documents were set up to persuade the banks and the institutions to release assets. And I find in practice that most banks and most sophisticated account owners, account holders, are going to require the longer form affidavit, if only to protect themselves.
Sure, it does make sense. So those are some very practical issues. Well, we've been talking about ways to avoid go through probate, and of course some of these are shortcuts and can serve a very good purpose, but they have pitfalls, as Sully has mentioned to us. But there is a very common technique that's being used, and it's been used for the last 20 years now. It's very popular among the many of our clients, and it's called the revocable trust. Why don't you guys take a couple minutes to tell us your perspective about how that's a tool to make sure you don't have to go through probate?
Sure. Well, when you say going through probate, what you're saying is that the assets are in my name alone, and it has to go through this process to get to first pay my creditors and then eventually get to my beneficiaries. When you create a trust, you're essentially creating an entity or vehicle where you're already retitling your assets during your life or directing your assets to go directly to that vehicle at your death. There's no reason to go through probate, and because there's already basically an entity set up to be an auxiliary, an alternative to the probate process. Another huge benefit is, unlike when you just designate a beneficiary of your account, you can control the payments or the distributions, or at least give your trustee or the person you left in charge some controls and safeguards for what happens to that money. So for example, Richard, you do this trust, and 10 years go by and it turns out that one of your beneficiaries is now incapacitated or has an illness. You can design the instrument to say, well, it's his money, but I want my trustee to hold it and safeguard it for them and to spend it for them rather than just leaving it to them. While if we just have beneficiary designations, there's not much control other than pay the money to these individuals.
Well, that's very interesting because you can provide for more contingencies. But Sadie, how about from your perspective? What have you seen the benefits of using the revocable trust in this area?
Well, I think the times that we see it used most commonly is if there are multiple beneficiaries, if there are a lot of different people named. It does allow you to provide for contingencies. So if you had 5 beneficiaries named directly on an account or insurance policy, and one dies, there's a real risk that you're not going to get that updated, and it will pass under the terms of whatever contract is involved in the insurance policy or bank account or whatever account. If you've got it in a trust, you can provide exactly what happens if somebody predeceases.
That seems like a good idea.
It also is very helpful when there are minor children involved. That's a very common situation where there might be minor children whose shares need to be held in a trust until they reach a certain age, and the trusts give a lot more flexibility to do that.
That makes lots of sense. I'm sorry.
The one caution I was going to say is what often happens is people do set up trusts and then they forget to transfer their assets to the trust or name the trust as beneficiary, and that does sometimes that takes away the probate avoidance.
Yeah, that is the rest of the story that often doesn't get completed in that process. I understand that. Well, you know, we've covered a lot today. We've had talked about identifying non-probate assets to see if we can avoid having to go to probate. We've talked about assets that pass by operation of beneficiaries and so on. We've also talked about the use of revocable trusts. It's a lot to cover. But why don't we take a second now to get you on your final thoughts? Sadie, why don't you talk a little bit from the planning perspective about things that people could do in advance?
Sure. I think that in the right situation, joint accounts with right of survivorship, and normally I think the right situation for those is really for married couples or couples who are leaving everything to each other, and there's no reason for them to have it held in a trust. It just goes out right to each other. Joint accounts with right of survivorship work very well there. Beneficiary designations can work in a broader range of situations, but the key with those is to make sure that the people you want to receive the assets are the ones named, and to make sure that you update them frequently and review them and update them. Yes. And then in more complicated situations, in order to avoid probate, the revocable trust is really the best option. Okay, those are good suggestions for planning ahead. But Jonathan, we've done whatever planning we've done, and we still have to deal with things at the end of the day, and there are assets that need to be dealt with in some fashion through probate. Tell us a little bit about your final thoughts about that. Well, there's no question that this is a huge responsibility that's usually left to a family member, whether they've been appointed executor or they just know that they're the responsible son or sibling that's in charge. And what I find is a lot of people seem to think, well, I'm the one in charge. I need to get to the courthouse. I need to qualify as this person's executor. I need to take control of their affairs. And there really is no rush. And that really is the message that needs to get across is, people need to take their time. There are important things going on. It's a difficult time. There are funerals to arrange and to attend. There are family to spend time with and to mourn with. But figuring out the assets and figuring out the creditors, very, very, very rarely is it a rush, and is it an emergency. And I would just recommend that people take their time, go through these person's documents, go through their affairs, stay organized, create a spreadsheet, create a Word document, create a file organizer in some way to organize all the information so that the person in charge knows what they're dealing with, and to come up with a full plan before taking any major step. Before qualifying, make sure you need to qualify. Before dealing with any particular asset, understand the best route and most efficient way to do it. And if people are a little confused or not sure about the best course to go down, talk to a professional and somebody that can at least start them off on the right foot. The consequences of going down the wrong road, or for example, qualifying when you don't need to, is essentially a huge amount of stress and extra expense and burden that might not otherwise need to be done.
Those are very, very good suggestions. You know, we've covered a lot of material in a very short period of time, and I really want to thank, Southey and Jonathan both for taking the time to point out, the probate process and how we deal with non-probate assets, how we deal with probate transfers, and some planning ways in which to maybe avoid having to deal with some of the things down the road. So again, thank you very much for taking the time today to talk to our viewers.
Thank you for having me.
You're very welcome. Our guests today have shared some very important information and described tools to deal with the probate and administration of small estates, both from a planning perspective when titling assets or naming beneficiaries, but also what to do after someone has died, and none of that can be changed. We are grateful for them for taking the time to do so and hope you found the discussion helpful. I know I did. Here's what I think is especially relevant. Every situation is unique, but think about what you want to accomplish when you name someone as a joint owner of a bank account. Be sure this is the right way for you to plan for the probate of your estate and that asset. If the family is now trying to settle an estate of a loved one, take the time to understand how all those assets are titled and who are the beneficiaries of life insurance or annuities or retirement accounts. Once you sort through all of that, you may be able to use one of the small estate affidavits to transfer the remaining assets and avoid getting on the probate train. As you sort through the estate of a loved one to determine how best to proceed, I hope the discussion today proves helpful. But remember that the information provided is no substitute for getting advice and guidance from a probate attorney who can best help you determine whether or not it is necessary to get on the probate train. No point in taking a probate trip if one is not necessary. This brings us to the conclusion of our show today on the administration of small estates. Replays of this show, along with other helpful material on the topic of today's show, will be posted on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.